Okay, hello everybody. My name is Bouvier Yulin and I'm the director for SCMA. Welcome to Divorce Without Court, a better way to divorce. This event is in webinar format, which means you can see and hear us, but we cannot hear and see you. This virtual event is also being recorded and will be made available on our YouTube channel by the end of the week. If you have any general questions, please send either me or Taisha a chat, or you could email us at info@scmediation.org. I will now turn it over to our California Mediation Awareness Week Chair, Outreach Committee Chair, Marlon Shulman.
Thank you, Bouvier, for not only the introduction, but the wonderful work that you and Taisha have been doing for so long, helping to put this together. And thank you all for joining us in recognition of California Mediation Awareness Week. The Southern California Mediation Association, otherwise known as SCMA, is pleased to present this week's programs. The SCMA's aim for this week is to promote mediation to the wider community, engage with professionals, and encourage as many people to use this form of dispute resolution, as well as talk about it. If you are not familiar with the SCMA, I'd like to take just a minute to introduce you to the organization. We're the largest professional association of mediators in the state of California. Our mission is to nurture, expand, and develop the practice, profession, and community of mediation. We do this in a number of ways. We offer 2 major educational conferences per year, FMI, or the Family Mediation Institute, which will take place May 20th to the 22nd in the desert. It will be a great destination conference. I encourage everyone to check the SCMA website to see more details. We also host our annual conference every November. Both conferences draw top-notch thought leaders, much like today, in the field and are excellent networking and educational events. We offer a number of ongoing online programs throughout the year, such as this one and other trainings and workshops. We have PDGs, or professional development groups, where our member mediators network, share ideas, get feedback on various situations. We also offer a number of social events through the year for networking. Most importantly, an SCMA is a supportive group of positive individuals from a variety of educational and professional backgrounds committed to mediation and conflict resolution. Whether or not you are a mediator, if you would like to learn more about the SCMA, please visit us at scmediation.org. That's scmediation.org. We have the benefit of being sponsored this week by a company called ODRI, Online Dispute Resolution International. Wonderful company. You'll learn more about it in a moment. I think Bouvier has a short video for it. Thank you. Audrey is a marketplace platform for online dispute resolution that was born out of the recognition that people should have multiple, accessible pathways for initiating and resolving their disputes. Audrey, ODRI, focuses on bridging the gap between individuals experiencing disputes and professionals who could help resolve the disputes, such as mediators. The platform is designed to support numerous users, allowing them to conduct the entire negotiation or mediation process online. Parties experiencing disputes can negotiate with each other directly or request the assistance of a mediator listed on the Audrey platform. Audrey helps parties to resolve their disputes faster, safely, and cost effectively. As they say, click to resolve. I think I'm going to pass it over to Bouvier to make some introductions, and I thank you very much. I look so forward to this wonderful panel. Thank you for all coming.
Thank you so much, Marlon. Now I'd like to introduce our moderator for today's webinar, Lynette Kim. Lynette is a divorce and collaborative divorce mediator. She sits on the board of directors for the Southern California Mediation Association and co-leads our Family Mediation Professional Development Group. Lynette, the floor is yours.
Thank you for that introduction, Bouvier. I'd like to introduce today's panelists, Chip Rose, Layla Balakane, Lori Itkin, and Dr. Jenna Flowers. Chip Rose has been the director of the Mediation Center in Santa Cruz, California, and certified as a specialist in family law by the State Bar of California Board of Legal Specialization. Chip is recognized nationally and internationally as an innovator and expert in the field of mediation and collaborative conflict resolution. He is a founding board member and the past president of the Academy of Professional Family Mediators, and previously was a member of the board of the International Academy of Collaborative Professionals, IACP, the first international organization in the field of collaborative practice. An adjunct faculty member of the Strauss Institute for Divorce Resolution at the Pepperdine University School of Law, he teaches workshops in basic and advanced mediation and collaborative practice. Chip is also the author of numerous articles on divorce mediation. Layla Balakane is a distinguished and experienced mediator, facilitator, coach, and trainer who specializes in highly charged divorce matters, as well as other types of family mediation. She is a member of the Los Angeles County Bar Association's arbitration panel and is a certified practitioner of the Academy of Professional Family Mediators, APFM. Layla trains a wide range of professionals in the field of family law mediation through SCMA's Professional Development Group. Layla is a passionate mediator who has always felt drawn to help others navigate conflicts and advocates for children who will inevitably shape our society. Lori Itkin is a financial advisor, wealth manager, and certified divorce financial analyst, a CDFA. She serves on the National Board of Directors for the Association of Divorce Financial Planners and is the author of the Amazon's bestseller, Every Woman Should Know Her Options, Invest Your Way to Financial Empowerment. Through her company, The Options Lady, she provides divorce-related financial planning and analysis to individuals and couples throughout all stages of the divorce process. Lori earned her Bachelor of Science in Economics with a concentration in finance from the Wharton School of the University of Pennsylvania. Jenna Flowers, a doctor of psychology and a marriage family therapist, has a private practice in Newport Beach and is the clinical director of Mainspring Family Wellness, offering counseling services and parenting classes. She offers an online course for co-parenting called coparentwell.com. Her book, The Conscious Parent's Guide to Co-Parenting, is published by Simon & Schuster and can be found on Amazon and Barnes & Noble for purchase. Dr. Flowers is also the co-host of Mainspring Family Wellness podcast, discussing all things parenting and all things family wellness. Welcome to all panelists, and thank you for being here today. Each of you will have about 15 minutes discussing the topics we've prepared. As for questions from members of the audience, please use the chat box function to pose your questions. I'll try to get to the questions as soon as I'm able, but if I do not, please know that I'll get to them before the end of the program. Layla, good afternoon. Layla?
I apologize, I was on mute. Hi, Lynette.
Hi. Leila, would you share with us how mediation works? What are the major differences between a divorce matter that is handled through mediation from a divorce matter where the parties are represented by lawyers and litigating in the court system?
Well, first off, thank you, Lynette. And again, thanks to STMA and especially Taisha and Bouvier and Audrey for putting together this forum. It's really wonderful to share this hour with good friends and colleagues. You're all deeply appreciated. So mediation, where can I start? Mediation is a growing approach, and it's becoming a more favored approach by both families and the court. You work with an experienced, neutral third party, and that person helps you reach an agreement. Mediation is really designed to help families have meaningful communication, especially when there's children involved, because you really get to focus on the children. And what really damages the children is the ongoing conflict between the parents. So there's so many reasons why mediation is impactful. And I'm really in this field because I find it incredibly empowering. You can make decisions rather having the courts make decisions for you when you're in mediation. And what I really do appreciate most in my practice and been doing this, that mediation really helps individuals to respond with empathy, because it gives them the ability to understand what others feel through a completely different lens. And you're now listening differently and having heartfelt conversations. And because of these conversations, a lot of times that in my practice that I see that couples actually discover divorce is not what they really wanted. So this is really a process. Other things to note about mediators that we don't provide legal advice, but we do provide you with legal information and help you come up with creative solutions. So there's so many reasons that mediation would benefit your families. And I really don't have, unfortunately, we don't have enough time to cover all of them, but I want to share with you some of the important ones. So with mediation versus litigation, you save time. It's definitely a faster resolution, because if you're in litigating, it could take sometimes years, whereas mediation, you can finish in a matter of days or max a few months, and you really can reach a resolution at your own pace. It's definitely less stressful. I mean, we all can agree that just going through the divorce process is stressful enough, and being in litigation, it exacerbates largely because you don't know what's going to happen. It's the fear of knowing, it's the fear of lack of control. And when sometimes my clients refuse to work together and insist, Leila, that's it, I'm deciding I'm going to court. And I asked them, well, do you have any idea what that looks like? How would you go to court? And it's not that simple. You just show up and tell the judge, tell us what to do. You might need to get an attorney. You might have a deposition taken. And then you each have to prepare briefs, arguments, and then you have evidentiary hearing, and all that could take months. Also, when you're litigating, especially when there are kids involved, you really don't speak with the other parent, and it creates a negative pattern for ongoing co-parenting, where what we try to do in mediation is build a co-parenting relationship and create a model for communication. Another great benefit is creative solutions. My clients often ask me, Leila, if we decide to divide our asset this way, is it okay? Is the court going to reject our settlement agreement? And I want you to all know that in mediation, you could do whatever you want as long as you both agree to the terms and you're well informed about the decisions you're making. Your options are limitless. And sometimes I tease my clients that the court would even agree if you decided to leave all your assets to me and you two negotiate the debts. The court will probably accept that, but somehow they never accept that option. So mediation is a negotiation process. Other things that can to note, mediation can happen in person. It can happen in video conference. You can do it through phone. I mean, there's so many different video conference platform. Sometimes, depending on circumstances, I might have a joint session with both the couple, or we can have individual separate session. And again, clients ask me, can you keep the conversation in the individual session private? And I would just tell them that I will keep confidential any expression of thoughts and feelings, but what I cannot hold confidential is factual information. So for example, if somebody says, I got a crazy amazing bonus and I don't want you to share that with my spouse, well, I have to share that information because that would be critical information in my mediation. But if you say to me, I'm really scared to death of what's going to happen, where I'm going to live, where I'm going to move, I will keep that confidential. Another thing is that mediators are not judges, and we come from different background. The mediator is not a participating law or therapy in mediation, but mediators can provide legal information or psychological insight. Lastly, in mediation, we always have the options to bring other experts. I always work with my good friend, Lori Itken. She is a certified financial analyst. And I often work with her to analyze the restricted stock unit and stock options, which I always appreciate you helping me out, Lori. I also work with mental health professionals who are incredibly helpful in difficult co-parenting situations. So I hope that helps answer the question as in a nutshell what mediation is.
Thank you for those comments. And these conversations that the parties have with a mediator in mediation, are they private and confidential?
Yes. So let me explain a little bit what the confidentiality concept is. It's meant to protect the spouses from what it said during our meetings in the process of settlement. You may say things, you may disclose things that you may not in a more hard-nosed environment. So what the confidentiality agreement means that if you ever go to court, my notes and whatever documents you presented during the process of mediation will not be admitted to court. So it protects the mediation process and it makes the parties feel more comfortable. But it really comes down to just remember that your negotiations are kept private and they're not in open court. You don't write declarations. Your attorney doesn't write a declaration stating your position and why, but rather that you sit down and you talk to a mediator privately among yourself in the process. And those conversations in joint sessions, or like what I explained, even with individual sessions, it will maintain privacy and be kept confidential. So it's not going to go outside beyond our session.
And what are the typical costs of mediation versus litigation?
Most people choose to come to mediation because it's less expensive and it's less time consuming. The average cost of divorce mediation is generally 80 to 90% less than the total legal fees in an adversarial setting. Because in litigation, you have two attorneys who are in the adversarial setting. And in mediation, you're working with one neutral mediator. And that one neutral mediator will likely spend far less time than the two attorneys who are working with the court. But I always encourage my clients to have their final agreement reviewed or questions answered by an attorney. But you use your attorney sparingly for specific purpose, right? Because you can have an attorney that you can consult with and answer your questions, but not an attorney that's going to cheerlead you into arguing on fighting in court. So we always refer you to lawyers who are mediation friendly, who understand the value of mediation, and they can help you again, review your agreement and answer your questions.
Thank you. It sounds like mediation makes a lot of sense, and it is the way to go for a lot of cases. How does one get more information about mediation and choosing a mediator?
So like I mentioned, mediators come from all walks of life with different diverse backgrounds and experiences. And they each have their own approach and styles to mediation. So I would, ask professionals, ask teachers, words of mouth. If you have a therapist, your therapist. Nowadays, mediators offer a free complimentary session. So I would, check out the mediator website and see what their background is, and then interview a couple of them and just see who you feel most comfortable with, and see who seems to have the most well-versed in the area that's a concern to you.
Thank you for your responses. Very helpful. And I am going to move on to our next panelist, Chip Rose. Good afternoon, Chip.
Good afternoon, Lynette.
Could you share with us, Chip, with your many years of experience as a certified family law specialist and as a mediator, what is important to know between mediation versus litigation?
Well, for one thing, I always like to take a sort of 1,000-foot view of a situation. And the 1,000-foot view of clients who come in to find out about divorce is their lack of recognition about the power that their fear, concern, anxiety, and lack of information affects their decision-making process. Just for example, I would say at least 90% of the clients who came in and consulted with me over the past many decades, the first question out of their mouth is, I just want to know what my rights are. And my response was, why are you aiming so low? Do you actually believe that the California state legislature is out to protect your rights? There is a set of codes that they developed for policy reasons in California as to why we would be a community property state instead of an equitable distribution state, for example. But the goal wasn't to make sure that any individual was protected. The goal was to say, these are the rules in living in California and being married in California. And so I think it's important to address the power of that fear and anxiety that clients come in with, because inexorably it causes them to make bad choices. And one of the choices they make is to follow what they hear from many family members, which is, you need a really good attorney. The irony of that is very few people can refer to an outcome that they got with a really good attorney that they're pleased with, because by and large, the whole process of going through the court system is one that is incredibly damaging, incredibly expensive, and it doesn't help in any kind of a healing process, especially when you have a family that has children and the children's lives are very much at stake. So the focus in litigation, when clients choose to hire an attorney and go that route, is to control as much information as possible so the other side doesn't get anything which is advantageous to them, which is reciprocated by the other side. And it creates this whole environment that you're at odds with each other and you're kind of at an intellectual war with each other. The focus of mediation is to say, let's strive for the goal that the two of you get the best results that your circumstances can provide. Now, every couple comes in with a finite set of financial resources, but the division and the agreement around the division of those resources can vary from the most minimal, which is typically what the law ends up providing, to the most maximal, which is what two people can do when they treat their circumstances as a problem to resolve, as opposed to a war to fight over and see if they win, with all of the damage that comes with it. Furthermore, in litigation, the legal processes are so complex that quite frankly, lawyers don't take a whole lot of time explaining to clients where they are in the process and what's going on, because much of it is beyond the client's capacity to handle. In mediation, the clients are being fully informed because the process is about them. The process is one that will depend upon the clients each arriving at what they find to be an acceptable, mutually acceptable agreement, which means they're informed. They're in control because they don't reach a settlement until they're ready to do so. And they're protected, unlike the litigation process, because they have the resources of mental health professionals, financial professionals, and legal professionals, plus the skill of a mediator who can facilitate their conversations and help make sure that all of the options that are available to them are put on the table. And the difference in litigation, where the parties, I can't tell you how many cases I settled in the cafeteria of the courthouse the morning of the trial. And you want to talk about a terrible outcome. That's what happens at those tables. In mediation, I can't say that I ever had any of those. And I'm talking about thousands and thousands of couples that have successfully resolved their issues in a way that didn't damage their family, beyond the fact that divorce is damaging. We all know that. It has an impact on children, but it can range from the worst to the best. And mediation offers clients the opportunity to aim at achieving the best. So the assumptions that underpin litigation, that clients are protected, is a mirage. Once the clients get there and they're engaged in litigation, they find that the cost of maintaining it and the emotional and psychological damage to each other and their children was never worth the price of admission. On the other hand, clients who engage in mediation, even if they don't complete the process, which is very rare in my experience, nonetheless, they're so much more intelligent about what they're doing. They've been informed about their circumstances. They've been informed about what the choices are through shared conversations with both parties. The costs are reduced enormously because you're working not only with one professional, as Leila said, but the mediator gets to know each of the parties, and in assisting them in negotiating with each other can help them avoid wasting time with proposals that won't go anywhere, and instead focus on proposals that actually appeal to the other person's interests, self-interests. I mean, I want to not take too much time because I could go on all day about this, but those are some of the fundamental differences between mediation and litigation.
Thank you for that. And when you say that parties are informed about their choices and they have access to specialists, does this mean that the participants get help understanding the law about whatever problems they are trying to resolve?
Yes, it's important to understand that the legal profession has a monopolistic interest in controlling information about the law. It's important, as Leila said, that mediators don't give legal advice, because mediation is a profession. It is not something that requires a legal background or a mental health background or a financial background. It's a skill that a professional can acquire. But nothing prevents any of us as citizens from talking about the law. So it isn't as though a mediator has to put on a white coat and say, I can't discuss anything relating to the law. You'll have to go to a lawyer to find that out. All kinds of things can be discussed about the law that are objectively knowable without necessarily giving legal advice. The term legal advice is greatly misunderstood. So the idea that a mediator would make sure that the clients, well, I put it this way, in my consultation with clients, I said, we're going to look through 3 different lenses at your circumstances. One lens is California family law. So what do your circumstances look like from what we know about California family law? And the answer is, there are laws and rules under California family law that very much appeal to one of the parties and says, I like that, I want to use that. And guess what? You can. But the idea that the law answers all of the concerns to create a nice negotiating environment for the parties to be able to make a bargain with each other is a tremendous falsehood. So the law is one lens, and it's important that they look through that. And whether they get that help from outside by having a consulting attorney, or whether they each go to individual attorneys, if they're committed to work in mediation, then they're just bringing that information back. They're not bringing it in as a sword or as a shield. The second lens is what are things that are governed by the everyday world that we live in? And that includes healthcare coverages, mortgages, interest rates, credit cards, scholarships. I mean, there's just a million things that are the business of life that we are all plugged into, that the legal system doesn't consider relevant to a family law decision. And yet they're hugely impactful. So for example, the amount of capital gain that may be in a residence that one of the parties wants to keep, and the other party wants offsetting equal assets that have no tax liability associated with them, the person keeping the house might want to know, oh, by the way, you're going to owe money on this one day. And the other person would look at it and say, well, for the comparable amount, I won't owe any. That might be important to them to know. And the question for all of us as professionals is, are we making sure that the clients are learning and becoming fully informed? So the first lens is family law. The second lens is the real world. And the third lens is, what are things that can only happen because mom agrees to offer something to dad in exchange for something dad will give mom? And it's that bargaining center that allows the clients to get away from fear-based negotiation and actually engage in the common language of trades, of making trades with each other. And in order for that to work, they both have to feel fully informed, and they both have to feel they're getting all the help they need to put those together. So when I'm helping clients, for example, put a proposal together, I'm not trying to design it. I want them to design it. I'm there to help them realize, wow, there's a whole lot of pieces on the table here you haven't used yet. Do you want to put those into your proposal because they'll add value? And everyone in the world is comfortable with simple negotiating. We do it every day of our lives. Moms do it with their children. Moms do it at work as CEOs of corporations. Men do it. Everybody does it. We just don't think of it in the context of emotional conflict. And it's the ability of a mediator to help the clients recognize there's the emotional underpinning to all of this, and it's real, and you need to recognize it. But much more importantly, look at doing this in a rational way that helps you achieve your self-interest while you help facilitate the other person achieving theirs. Obviously, it ends up being a compromise. Trades are made. I mean, those are, to me, some of the critical differences that you get to do in mediation that I never got to do as a lawyer representing a client in a divorce case.
Thank you. We have a question, and Mandy asks, what if only one spouse wants to mediate? How do I get the other party to the table?
Well, what that immediately brought to mind, because I think in pictures, is one hand clapping. You know, there's no noise. It takes two parties to agree to mediate. The real problem is, and I've had numerous clients contact me over the years interested in mediation and concerned that their spouse wouldn't necessarily agree to do it. And part of my advice to them has been, well, if the separation and the decision to get divorced is fresh, and the person who's resisting is the person who didn't want to end the marriage, you may need to give them some space and time to just get to the point where they actually have to make a decision about process. That'd be number one. And number two, give them my number and ask them to call me. And if they're willing to at least make that phone call at no expense, I can help give them information that will clarify the choices that they're facing.
Thank you. I think Mandy's next question can be addressed by Lori because it has to do with financial information. So Lori, good afternoon.
Good afternoon, Lynette, and thank you, SCMA, for inviting me. I'm a big supporter of the organization, and I just want to say how much I appreciate Layla's and Chip's comments based on their experience regarding mediation.
Thank you for that. I agree. I totally agree. So Lori, tell us, why do couples in mediation hire a CDFA like yourself?
Sure. Well, first of all, CDFA stands for Certified Divorce Financial Analyst. And you know, as Chip was saying, what's interesting, he said that he talks about 3 lenses when potential clients come to him. And the first, he talked about what is California community property law? What are the legal parameters? Well, the vast majority of my practice is devoted to supporting either individuals or couples in mediation. And the most common theme I hear from clients is that they just want to divide community property fairly. You know, they want, you know, it's very common that people say, I just want to divide, we just want to divide everything in half. So why would you need a CDFA? A CDFA is a professional who is educated on the financial and tax impacts of divorce. And I specialize in California, and obviously every state has their own laws and nuances regarding family law issues and divorce. So if somebody says to me, a couple, we just want to, you know, divide community property 50-50. Well, number one, we have to figure out what is community property and what is separate property, because community property presumptively is going to be divided 50-50 as a starting point. And so there are many issues where separate property comes into play. Imagine, you know, Mary owned a condo before marriage. Rodney moves in and lives there for 3 years. They get married. Then the community is paying down the principal on the mortgage. Well, Mary might have owned the house, you know, previously, but 20 years into the marriage, there's a community interest developed. So how do we figure that out? A separate property, you know, in a pension, there's community property, there may be separate property. This is increasingly important as couples are getting married later in life. They've come into the marriage with established assets. And if they don't have a prenup, then it is going to be incumbent on them to learn how they can trace their separate property claim and what information is going to be required to defend that claim. And let me tell you, in mediation, you know, people think, well, I can't use a mediator for this. You can go in mediation and do this. You don't have to go to court. You know, and just thinking about, even if you want to divide, let's say everything is community property and you want to divide it 50-50, you can't split a house in half. And as Chip talked about, the person keeping the house may not even be aware that there are capital gains ramifications. And so the value of an asset on paper may look 50-50, but once you start thinking about the tax impacts, if you're not aware of this and you as couples are not educated, you may be left, one spouse may be left with 60% and the other 40%. So that's very important.
So I think Mandy's question is relevant here. He asks, do you have access to financial information or any other important background information before you start to mediate?
Yes, great question. I often, we're going to talk a little bit about a CDFA as a neutral or a CDFA as an advocate, but no matter how you get divorced, you know, lawyers, mediation, online, do it yourself, each party is required to disclose assets and debts to each other, both separate property and marital. They have to disclose income and expenses. So every mediator has a different way of doing this, because I've worked with a plethora of mediators, but a very important process in the mediation process is the financial disclosures. There may be, people are always, oftentimes the client is worried that their spouse is hiding assets. Great way to bring a CDFA. I can look at a tax return. I can look at the disclosures and do, you know, working on what over 280 divorce cases now, I have a pretty good idea when something is suspicious and maybe somebody's hiding money. But typically a spouse is not hiding money. It's simply that the other spouse is suspicious. Trust has been broken over a variety of issues. And so, you know, working with the CDFA can help both parties feel comfortable that all the financial information has been disclosed.
And what are the financial considerations one needs to know in order to make an informed agreement? Okay,
so let's talk about a CDFA, because a CDFA can play 2 roles. So they can either be working with a couple as a financial neutral, or working with one party as an advocate. I do both. And so when you're looking each party needs to make an informed agreement. When I'm working as a neutral, my focus is on helping people understand what are all the assets and debts, how they may be divided, maybe looking at what's income available for support. If you have self-employed people, you don't have just a W-2. If you have an S Corp, you may have a W-2, you may have a K-1. There are really 4 components: dividing assets and debts, 1 and 2, and determining income and determining expenses. So as a financial neutral, I can really, in a way, be an educator and advocate to both parties. As an advocate, why people hire me as an advocate is when they feel like the other spouse is more financially knowledgeable, more financially savvy, and I need to work with that one spouse to get them financially literate so that they can make informed decisions and make proposals and respond to proposals in mediation. So if you are, to your question, what are the financial considerations somebody needs to know in order to make an informed agreement? Number 1, where I come in, is understand if you accept this proposal or you make this proposal, what are the short and long-term financial impacts to you and your children if you choose this route, if you agree to this settlement? Or what if you agreed to a slightly different settlement? How would that impact you? Things like a spousal support buyout. Are you better off receiving spousal support for 10 years or getting it all up front? We want to understand how it's going to impact you in the future. I also think the financial considerations you need to know in order to make an informed agreement is understanding the parameters of the law, getting that legal information, because I don't want you to divorce and have regret that you were not fully informed on the legal issues and the financial issues when you're negotiating a divorce. And at the end of the day, you want to make sure that you are set up so you don't run out of money when you're 70, 80, or 90. Divorce is the largest financial decision you will probably have to make in your lifetime. So make it informed and be proud of what you've done. And mediation is a great way to do that.
And when you go through this analysis with the parties, do you perform this analysis for both of them, or are you speaking of a situation where you're doing the analysis more for one person than the other?
That's a great question, Lynette. I do both. Often when mediators introduce their clients to me, in most cases, they'd like me to perform this as a financial neutral. One example would be if one spouse or both spouses here in California get equity compensation at work, we need to figure out what is community and what is separate, because things vest over time after the separation, after the divorce. In that case, I can be a neutral, but sometimes people hire me as sort of a mediation mentor or coach, a financial coach. When they're going through mediation, they want to understand what's in front of them. They want to understand how to evaluate their spouse's proposal and how to form a counter proposal.
Thank you for that response. There is one question from Sonal, but it's directed at Chip. And so I'll save that question until after we've had a chance to discuss the emotional impact of a divorce with Dr. Flowers. So hold on just a sec. Dr. Flowers, good afternoon.
Hi, Lynette. Thank you very much for having me, Southern California Mediation Association. It's a pleasure to be here.
Thank you for being here.
Yeah.
Dr. Flowers, we often get as mediators the question that the party's greatest concern is for the children. Mm-hmm. And so how does using mediation in a divorce proceeding benefit the family?
Well, first of all, divorce is a rupture for children. It is a major life change for children. It changes the world as they know it. And so parents, when they go into their divorce proceeding, have to think about this in terms of what kind of setting do I want to create in ending my relationship with my child's dad or mom, so that I'm creating a new baseline for how we can work together in the future. And that's why I think mediation is such an ideal platform rather than a divorce proceeding in the courts. I've actually heard it said, and I really agree based on what I've seen in my own practice and when I see court mandated co-parenting couples, that typically for a divorce to have to go into the courts, it's because one person at least has a characterological disorder or personality disorder. There is some kind of very strong intent to want to just fight and fight at all costs without any kind of consideration about how it's going to be affecting the children. So mediation really helps kind of start to already build the co-parenting for parents, and also to learn how to compromise, because that's going to have to continue. See, even if you divorce somebody, you may be relieved that, okay, that relationship has ended. But if you have children, no, that relationship is still continuing, and it's going to continue on, especially if you're little ones, for at least 18 years plus. So you have to figure out a way on how to work well with each other for the future of your kids. And the other thing too is that when divorce is a rupture for your children, you are in charge of still teaching them based on their development, how they're going to develop as people, as well as just their care. So it's not just about figuring out schedules. It's about how is this child going to develop after the fact of this? How do we both work together to take care of them so they become healthy, self-corrective adults for the future?
Thank you for that. And can you explain to us what exactly is co-parenting and how does it work, and how do you come up with a co-parenting plan?
Yeah, so co-parenting is basically the shared responsibilities that both parents would have to raise their children. So it is about coming up with maybe a proper schedule, and also abiding by the schedule that's been agreed on. But it's also about how is this child emotionally, how are they academically, what's happening for their health care, what are we doing to support their development as an athlete or as a star singer or whatever it is that your child really enjoys. It's making sure that things don't fall through the cracks even after a divorce. That both parents are engaged in sharing those responsibilities and then also being engaged with their kids. And you do have to work things out with your fellow co-parent in order to ensure that these things are happening for your child.
And there are those situations where spouses completely disagree on who should have custody of the kids.
Yes.
Is it possible to reach an agreement in such a situation?
Well, first of all, I always say the ideal is 50-50 custody, right? With that being said, the caveat being that you have two parents that very much want to be involved in that child's life and that are engaged in all the aspects of how that child is developing. Now, there are certain things that come up, you know, if you, of course, have there's one parent that has a drug problem or an alcohol issue, or maybe one parent works a lot and they don't want to be as engaged, then I think those things do have to be taken into account and discussed. And then that's where then you also have to invite sometimes other professionals into and their advisement into the mediation. So some people do need to have a 730 evaluation where one person may think that they should have equal custody and they're really not very fit to have that kind of custody. That kind of information would be important, and you still very much could bring that into a mediation rather than into a court proceeding. I also think that you have to be honest with yourself in figuring out your custody as well. If you don't really have appetite to be as hands-on, because it's really children, it's not just about quality of time, it's also about the quantity of time. And a lot of times parents think, well, as long as I get, you know, a really good weekend in with the kids and I take them to Disneyland, or I do that, you know, we call them like Disneyland dads or Disneyland moms. That's not the case. It's really the grittiness of like sitting down with the tough math homework, Or if you're not so good at math, then at least you found a really good tutor that can come in on Tuesdays at 4 o'clock to make sure they're meeting with your kid. You know, it's the hard stuff, and who's going to be there for the hard things for your kid, or also the pickup. Because, you know, I did have one case a while back where both parents, one was a stay-at-home mom, the other one was working, and he chose to have a nanny pick up after school. And it was really difficult for the mom to be like, well, why can't I just do the pickups? And this was one of those particular cases where it would have been so great to see, like, come to mediation, let's work this out. But they chose a different route. And this particular parent, though, decided, on my time, I need to own my time. And so I am having that nanny come in to do the pickups, and then I'm home by 6. And the other parent had to be okay with that. That now when you have 2 different homes, there's going to be sometimes different rules and setups at each home. And you have to be okay with that, because there is a change of landscape. Your kids have to adjust to how dad is going to approach certain things and how mom is going to approach. Now, here's the great thing about how mediation can help with this. When it's kind of like what Layla was talking about earlier, you can come up with whatever creative solution you want to have for what fits for your family system. Because see, there's still a family that's here. It's just the family system is going to look different now. And the more that your kids understand that, like, these 2 parents that love you so much are always going to be involved in your lives, and we're finding the different people and resources and community to make sure that you guys are supported in this process, you know, they're going to be better for it. They're going to feel cared for and loved. So mom had to adjust. And that's just part of that landscape for that family. And I think when you go into mediation, you could actually work out, like, can I still have pickups after school? Even if we're 50-50 custody on paper, can I still do that? And then you just pick up at 6 o'clock. Yeah, there are families that do that. It doesn't always have to be so rigid. It can be whatever you guys work out. I know for myself, being a divorced mom with 3 kids, and we used a mediation, and it was a great process for us because I have certain work hours that are different from my ex-husband's. He can do pickups more days than myself because I have to have school hour availability often for my private practice. And then I have a pickup at 5 o'clock, and we both have 50-50 custody. But you have to approach it from a mature fashion of also what is in the best interest of the kids. For ourselves, we didn't want somebody else having to pick up, because we both know we are the important people for our kids. We know what our children best. And when you go into a mediation process, you can lead with that. You don't want other people necessarily making decisions for you, for your children, if you are both willing to work on it together.
Thank you. Those are great comments. You use the words being honest with yourself. Mm-hmm. Now, we've all encountered those parents who are frankly not able to be honest with themselves, and they insist on a certain parenting arrangement when they're not able to abide by the agreement. And do you have any tips on how to deal with those parents?
I think that's where sometimes you do have to circle back. Like, mediation will help to create a level of accountability of what you guys have both agreed on. But then if somebody is not actually following through, whether it is their payments, child support payments, or whether they have certain days that they've committed for pickup in their custody arrangement, then I think you do have to circle back, because who ends up really getting disappointed? It's the kids. And they will often end up feeling like they don't matter or they're not important. And then we go into self-esteem, depression, anxiety. And I'll tell you, this came out from a legal journal a few years back. Children that have 2 parents that go through a divorce proceeding or mediation will initially have some depression and anxiety. But in the long run, if they're in a high conflict family for the long haul, then they actually have even more depression and anxiety chronically later. So the more parents are working on being accountable for each other, working through that, their kids are going to be so much better. And if one parent is really failing and isn't following through on what they said they'd be accountable for, then you do have to go circle back with your mediator and go, we need to look at this. Maybe you initially thought this was a good idea and that this was going to work, but our kids are really feeling it. And so let's find a different arrangement here. And you'll see it. You'll notice that there'll be a drop off often in mood or issues like that. And so oftentimes you'll have like maybe even a therapist that will be, talking about it, or you can try co-parenting therapy. You can also do some individual work to really help figure out like, what is your priority? How are you working and grieving through? Because that's another aspect, is a lot of people may not have fully been grieving over their relationship well, and then they bring that into a divorce proceeding or mediation, and their own emotional stuff is getting in the way. It's very common. In fact, I actually have a divorce recovery group. If anyone wants more information on that, the email is on that panel list. You're welcome to reach out.
Thank you for that, Dr. Flowers. We're almost at 1 o'clock, and the hour flew by for me. Such interesting information. I'd like to see if the audience has any questions, but first of all, if you do have any questions, please put them in the chat box. Sonal asked, Chip, this is for Chip. Chip, would you make a one-time call to the unwilling party regarding mediation?
In general, my answer would be no. There can always be a special circumstance that would compel me to want to do that. And the reason I would say no is I want the parties to take responsibility for choosing to be in mediation. Whereas if I reach out, and by the way, there's an old piece as a lawyer that would worry about soliciting a client by making that call. So that in my subconscious, there's that training. But beyond that, working as a mediator for as long as I have, I would resist doing that only because if the clients weren't motivated. Now, I might explain to the client who's asking me to call the other client, they may not be ready to do this yet. And you may just need to give them some time to catch up psychologically and emotionally with where things are. But I try to make it as easy as possible, telling them that there'd be no charge for the call. There's no obligation for the call, but I'd be happy to explain to them the things that I had explained to the first person who contacted me.
And there's a follow-up to that question, Chip. And I think I know what you're going to say. The question is, do you try and convince them to mediate or just understand their resistances?
Well, I speak to their resistances because their resistances, by and large, are incredibly misplaced. I mean, the rational side of any human being would look at the benefits of a mediated approach to problem solving than to litigation, for example. So more often than not, there's an emotional impediment that's in the way for that person, or a psychological impediment that's in the way. And some of that may be timing. The spouse who is urging them to consider it had only told them that he or she wants a divorce within the last several weeks, let's say, and they're in the first flush of emotionally reacting to that. And they just kind of want to say, whoa, I want this to stop, and don't want to see themselves as participating. But oftentimes in that case, a month or 2 or 3 later, and that person's now confronting real choices of, do we go and hire lawyers and do we litigate, or do I accept an invitation to mediation? They would then be open to listening to why that's such a good option.
Thank you. Jenna asks, I think this question is for Dr. Flowers. What would you do if you realized that one parent had a personality disorder and the kids did not want to be with this parent? Do you recommend a one-parent sole custody ever?
I think there has to be enough evidence gathered to make that kind of decision. So first of all, has there ever been some kind of physical, mental, or emotional harm that's been done to the kids? And if so, has that been documented with seeing a child therapist or a 730 evaluator? Is there a history of domestic violence? you want to understand like the real landscape of that before you can come to a conclusion that about the custody arrangement. And also it's as a therapist, it's not within my scope of practice to be able to say, hey, I really think that there should only be one person that has sole custody here. Typically, then that's gone to some kind of, to a higher level of legal proceeding in order for a judgment made that there's only one. Because you're not going to hear, if there is a true personality disorder, like a narcissistic personality disorder, you're not going to hear from that person that they're not going to want any custody. So you're going to have to really work within the courts at that point then to see that, and the proper documentation.
And Melinda asks, do both parties always meet together, or do they ever meet with the mediator on their own? Anybody who wants to take this question?
Sure, I can answer that. So in mediation, you have the option of meeting with, I prefer to do joint session. I think it creates a more level of transparency. But if someone is just very uncomfortable and wants to have separate session, I've done that too.
If I can jump on to Layla's answer, I'm actually structured so that the first phase of the process, which is getting all of the conversation issues, analysis options out on the table, is done in joint sessions. And then, and this goes back to when I first started doing this 40 years ago, and there was no model that I was aware of. I felt that I needed to meet with each of them separately to help them make sure they used all of those marbles to come up with a comprehensive proposal. Because when I found, when I had the parties in each other's presence, I often found that one party would make a concession to the other that I wanted to be a bug in their ear and say, ask for something back for that. Even if you don't think it has any value to you, it has value to the other person. Let's use all the bargaining chips on the table. And I got uncomfortable with the whole concept of an imbalance in negotiation. I saw more frequently when everything was done in an open session than caucusing around the negotiation phase. And I just made that a part of my practice. And I know it's not the way that most mediators operate, but it's worked for me.
And I completely agree with Chip. I think it's definitely important at some time during the mediation to have that caucus meeting with each party, because there are a lot of times that there are certain issues that they're not comfortable to be addressed in joint sessions. So you really get to see what their true feeling is in separate sessions.
And this is one last question, and I think it's for Dr. Flowers. What patterns do you observe in adult children of divorcing parents?
Oh, that's a great question. I think you may see some attachment issues typically. So, we have different attachment styles in the world, like secure attachment, avoidant, or ambivalent. And the ones that are more insecure attachment styles are avoidant or ambivalent. So you may see, if you didn't really do or have parents to help you navigate the proper work during that time to process the loss of your parents being together, you may see more ambivalence for that person about being in a relationship, a fear of being abandoned. You may also see someone that's just really able to cut off in relationship and then not talk and stonewall and just not deal with things. So it really just comes back to, if you find yourself in a current relationship now as an adult, like, go do the personal work you need to so that you can have healthy, thriving relationships. You deserve that. Everyone deserves to have their best life, but it does require you to put your work in to do that and make that happen.
We're now at 1:05 p.m. and this has been a most interesting discussion. Thank you to all the panelists for your time and the valuable information you've shared with us. We discussed the many positive attributes of what mediation can do in a divorce context and how families can peacefully solve their problems in their divorce without resorting to litigation in court. We hope that through this presentation, the public will become more aware of what mediation can accomplish. Thank you to the members of the audience for being with us today. And it looks like all the questions have been answered, and And this concludes our program. Thank you again, and have a very nice day, everyone.
Thank you, everyone.
Thank you.
Thank you so much. I just want to put up on the screen also everybody's contact information in case you would like to contact any of our panelists. I know they have shared a lot of information. And so in case you want to contact any of them, here is their info. I also included it in our chat. Again, this was recorded, and so it will be up on our YouTube channel by the end of the week. You can find us on YouTube under Southern California Mediation Association. Again, thank you again to all of our panelists. Thank you to everybody who attended, and I hope you all have a wonderful day.